Thank you, members. We're a little noisy. Please proceed, Senator Jackson.
And concerns of undue influence by commissioners in dealing with commission staff. SB 1190 will help restore the public's trust in this commission, ensure that decisions are made with transparency, and remove that backroom decision-making or public perception that backroom decision-making occurs. This measure will do this by codifying the independence of commission staff and banning ex parte communications in certain circumstances. As introduced, the bill would have banned all ex parte communications at the Commission, but recent amendments narrow the scope of the bill to apply only to adjudicative and enforcement proceedings. As we know, the Coastal Commission has a couple functions. Adjudicative is like being a judge. And in the courtroom, we require that proceedings be made public or with both parties or all parties present. Ex parte communications are limited, and in most instances in court proceedings are not allowed. Here, ex parte communications are conducted all too frequently by coastal commissioners, and we have discovered that either the information isn't provided as it's supposed to be, or is provided months later than the correspondence or communications occurred, or that the information is provided by the actual lobbyist rather than the commissioner. The public, needless to say, has been quite concerned as it has learned the way this Coastal Commission is conducting business. And these amendments bring the policy on ex parte communications at the Commission in line with court decisions that have found ex parte communications on adjudicative matters as a violation of procedural due process. Now, many of you are aware that the Los Angeles Times has been covering this, has exposing a number of these proceedings that were not previously reported, that there has been an enormous amount of influence by people who are quasi-lobbyists and otherwise people who are actually trying to influence these decisions without being so registered. The Coastal Commission, in essence, has somewhat run amok. And indeed, just a week or two ago, the Coastal Commission itself recognized that the importance of containing and controlling these ex parte communications and voted by a majority vote to support this legislation. This measure, members, will reestablish due process and fairness at the Commission. Now, it will not stop commissioners from being able to question and disagree with staff findings and recommendations. It just requires that those disagreements take place in the context of a public hearing. Commissioners will still be able to express their own views and vote as they see fit. I would also like to indicate to you that it doesn't limit the ability of coastal commissioners to participate with those who are trying to influence decision-making. It just means that they can't do it just in a one-sided fashion. It means that the others who have different points of view will be allowed to participate in those discussions. Ex parte means of one's own. It does not This bill does not limit robust discussions. It just says they can't be held in private, they can't be held behind closed doors, they can't be held in darkness. This measure is a good governance bill. As I mentioned, the Coastal Commission itself is supporting the legislation, and I believe that for those who are looking at another state agency with the function of reforming ex parte communications, this is consistent with that effort. This is consistent with what the public is entitled to receive and expects by way of these important proceedings. With that, I would ask for your aye vote.
Thank you, Senator Jackson. Senator Hertzberg.
Thank you, Madam President. You know, I want to say that I stand in solidarity with the author regarding the need to eliminate one-sided communications with the Coastal Commission. It is indeed, as she said, that as the stories of late run amok. Fair call. The bill is right in its motivation and its intentions. However, there are competing principles the right to a full and fair trial, for example, as well as operational complexities which require a deeper think, in my judgment, about how the legislature should proceed on this matter. I want to raise 4 issues. First, it's important to note that Assemblymember Terry Friedman, who served in this legislature from 1988 to 1992, sought to close the loopholes of one-sided, off-the-record communications. That law granted ex-parte communications to the Coastal Commission, but required communications to be reported in detail, I emphasize, within 7 days. And we know from recent history that that effort, however bold, was ineffective. Second, the Constitution and the Coastal Act require full and adequate participation by all interested groups and the public at large. However, given the realities of how the Coastal Commission operates and the magnitude of its work, I'm not sure how the Commission fulfills its mission. Currently, it's nearly impossible to get a full and adequate hearing without an ex-parte communication. I actually did the homework. I went back and looked at the last year of Coastal Commission agendas. There are 1,002 items on those agendas. These commissioners are basically volunteers. They work for 2.5 to 3 days for meetings, spend 2 days doing their homework, trying to get what's going on, and most people take 2 suitcases to Coastal Commission hearings because one's for their stuff and the other one's for all the paper they got to carry if the stuff is not otherwise delivered electronically. The folks that come, the commission tries to work around the state, and so some fella has a problem with his house for a 300-square-foot patio and has to go to Humboldt County to go have the matter heard. And they're given 5 to 15 minutes. The notion about how government works, the notion that there are other agencies that don't have ex-parte hearings, which is accurate, but they have full-fledged hearings where there's a process involved in terms of actually making it a fair hearing. How the heck do you have 1,000 of these things? It's almost the same number of bills that were signed into law last year by the governor between both houses of the legislature. Third, there's no prohibition on communication with staff in this measure. Lobbyists are experts at working with staff, as the people who are on staff know is the case. In a court, a party or their representatives can't go and come up and talk to the clerks of the court and ask questions and lobby them and explain what there's happening. Yet, this legislation does not prohibit communication with staff, just members who ultimately have the legal responsibility, members, to make a decision that could result, in the same tilted occurrences that we see today in the paper by virtue of activities with respect to staff. And fourthly, the Commission is different from other quasi-judicial bodies in that there is a government-to-government overlay where a city council or county supervisor or water district may need to communicate regarding the larger public policy issues that require attention and that may not fall into the type of transparency efforts envisioned by this measure. What I'm suggesting is that the underlying core of this reform makes sense. But often what happens with reforms, and certainly it's been in my experience, is that we rush to capture the moment, to let the public know that we are appropriately responding to a crisis. And that is important. But our efforts must be tempered by a longer view. The only law, members, the only law that we cannot amend, the only law that we cannot repeal is the law of unintended consequences. And so our job as a legislative branch of government is to do the homework. It's always to do the homework. Do the homework, do the homework, do the homework. That's what we're about. And so this measure, I thought about this long and hard because you're torn between, on the one hand, the importance of this. The author is correct. It is a cluster. It is a problem. There is no question about it. But the flip side is we have a real management problem of an 840-mile-long coast and all of the competing interests to figure out how to do it. I don't have all the answers, but I can tell you the following things. One, in order to fix this measure, in my judgment, we've got to spell out how the Coastal Commission can properly allow for full and fair hearings, given its current extraordinary work. There's been some discussion by staff that says, we'll have longer hearings. We'll allow to do this stuff. Well, you know what? That's a deeper responsibility in our sense. It needs to be in the statutory language. Two, explore extending the ban of ex-parte communications to staff or to enforce the reporting of such communications at the staff level so they are fully on record, as Mr. Friedman envisioned some in 1992. Three, create an avenue for local governments to communicate directly with the Commission in an open and transparent way so as it informs the kind of thinking that the author is trying to do with respect to this measure. Now, I believe, as I suggest, that the current version of this measure is flawed. But I will tell you today, I thought about this a lot, I will vote for this measure with the expectation and hope that some of these issues will be resolved before they return to this House. I think they're important. I think they're common sense. I think they're difficult challenges given the Coastal Commission. In my past life, I was deeply involved with the Commission. I know how it operates by virtue of making some of its appointments. So I wanted to share those concerns, but I am supporting this measure today. Thank you.
Thank you, Senator Hertzberg. Senator Pavley?
Thank you, Madam Speaker. I'm rising in support of this measure, and my fellow San Fernando Valley State Senator made some wonderful points as well on things we could look at. But let me give you my perspective. I was on the Coastal Commission and served on it for several years. I was a Senate Rules appointee from then Senate Pro Tem Bill Lockyer. I represented LA County and Orange County as one of the public members on the Coastal Commission. I know the problem, and it appears it's gotten even worse. I'm rising in support of this measure because I think I understand the scope of what goes on at the commissions and the scope of the importance in making decisions that are in the best interests of the public. You know, the Coastal Commission is a quasi-judicial body. It's not like being on a city council. People compare that all the time because we would meet with people, although as a council member, I only met with applicants with city staff present at City Hall, but that was a personal choice. But on the Coastal Commission, since it is quasi-judicial, we're like a court. We're supposed to be objective in the findings. What do we look at? We look for consistency with the Coastal Act. It really is quite a simple process. Yes, you have to read volumes of material, and I think, if I remember correctly, it seemed like 10-point font or less. I didn't wear glasses till I was on the Coastal Commission. You may want to consider that before being appointed. But there is a problem. There is undue influence, and it's not fair, frankly. People with a lot of money, applicants with a lot of money, will find wherever you live or you work and set up time to meet with you. Other people don't have access to you like that. Well, after several months of trying to balance teaching, because this is not a full-time job on the commission, it's 3 days a month, full-time job of teaching and a mayor in the evening and everything else, I realized it was not fair. But anyone who wanted to send me a separate letter, as long as they CC'd the Coastal Commission staff so it complied with ex parte rules, I promised to them I would read that and consider everything. Anything they wanted to tell me, because I'm really conscious about this, I don't want it to be in private. I don't want to be put in a place that it was perhaps a difficult situation. So I insisted from then on everything in writing. That meant the environmental groups could send things in writing, the local homeowners, the local city council people send things in writing. I read them all. They CC'd the staff. You comply with all the ex parte provisions, and don't let people with a lot of money and time to track you down and spend time with you give unfair influence before you stand in a court of decision as a coastal commissioner. I don't think it's appropriate to go out to lunch and dinner with applicants. And if you're on the Coastal Commission, you should know the people that are the lobbyists for these applicants travel with the commission every month. You become like best friends within a few years of time. They have, through relationship building, and you in the legislature can understand this, have developed a special line of communication with the commissioners. I think that's unfair. So you can meet with applicants. If you have a coastal staff member there, then you've complied with that. And I want to share with you, on any big projects, like I was around for the Hearst Ranch project. They were going to build lots of projects on the San Luis Obispo coast. Big projects, there's always a public field trip the month before or a few days before the final hearing on it, where busloads of people for and against the project, the applicants, the coastal commissioners, all go on a tour together, the media's invited, so they can point out the specific issues we're going to be discussing at a public hearing. I think it's a very fair process, as long as you make sure that you don't let people take advantage of the situation. I unfortunately think we need this protection in place for the Coastal Commission and in the integrity of the Coastal Act and due process because of the special nature in a citizens-approved initiative, and that was the Coastal Act in 1972, that we look very carefully at consistency with the Coastal Act in relation to making our decisions in front of the Coastal Commission. It demands and requires a fair process, just like being in a court of law. Ask for your aye vote in this measure.
Thank you, Senator Pavley. Senator Wolk?
Thank you, Madam President. I rise in support of 1190. I think that this is a good government bill, which is narrowly drawn. I think the author has responded to criticisms and has made amendments, and there may be yet more. But this is restricted to the times when the coastal commissioners are acting as judges. That's not all the time. That is there are some specific instances when they do that, and those are matters of usually great value is imparted by the decisions of these commissioners. Certainly, when there are development permits that are being issued, or if there is enforcement of an existing permit and its conditions, or unpermitted development is discussed. This is not unusual. There are many boards and commissions that have these requirements. Just a couple: the Commission on State Mandates, the water boards, the Alcoholic Beverages Control Appeals Board. This is not unusual. This is in the public interest. It's supported by case law. It exists elsewhere. It is good practice. And why is it good practice? Not only because it furthers better results, but frankly, it works against the belief that many people have that the process has no integrity. It's important that we believe that these processes have integrity and that these commissioners act in that manner, and that there are no secret deals that happen ahead of time or out of the public eye. That's what this is about. Discussion and adjudication on matters of serious import in the public eye. I ask for your support for 1190.
Thank you, Senator Wolk. Senator Morlock?
Thank you, Madam President. I want to thank the senator, the senator from Santa Barbara for proposing, I think, a very intriguing and helpful idea. And I also want to thank the senator from Ventura, LA, for her background on the Coastal Commission. I applied twice for the Coastal Commission. Senator Steinberg invited supervisors to apply, and so we thought it would never happen, but I applied anyway and filled out all the forms and got to know as much as I could. When serving as a supervisor with the California State Association of Counties, I served on the California Coastal Caucus and had a lot of fun working with all of my colleagues that had counties along the coast. And Charles Lester was very good to come and visit with us. And he was a quiet man, but very helpful, a nice guy. I wouldn't say he was a strong leader. And I would say that the Coastal Commission staff was not as efficient as perhaps I would have liked to have seen it run. Most of those applicants would somehow get their report from staff maybe a few days before the meeting, and it was so adverse that they would have to continue the item. So it was just a very frustrating process. So also I don't know if I mentioned it, but banning ranches in my district, which has certainly been a topic of discussion of late. So with that, looking at this whole thing, I think we're probably overreacting to something. I've heard the term, it's been run amok, but I think you've got to learn to let managers be managers. And I'm having difficulty, colleagues, with this whole idea of the ex parte communications and running a commission like they're judges. I would say that we ought to be looking at a different model. We ought to be looking at a city council, state senator type model where you do get to have input during the break, because these guys, they give, like the senator from LA said, they give 2 to 3 days a month, I believe. It's an amazing commitment to serve. And so I find them now being fined for failing to make notification of an ex parte communication is a little overboard and would certainly discourage anybody from wanting to even apply for this commission. So I think it's time that we reconsider the whole program. Instead of going in the direction that the good senator from Santa Barbara is looking at, I think we ought to take a step back and see if a better model can be pursued. I urge a no vote, excuse me.
Thank you, Senator Morlock. Senator Allen?
Members, I think that ultimately it's our responsibility in the Senate to appoint and support and put folks onto commissions like this who do have the independence and integrity to make the right decisions and be able to gather information as they find fit. I listened very carefully to the senator from San Fernando Valley, Senator Hertzberg's speech, and I do think that ultimately he summed up my core feelings about it and my ultimate decision on this bill. But I certainly do hope that some continual work occurs on this as it moves along through the process.
Thank you, Senator Allen. Senator McGuire?
Good afternoon, Madam President. Thank you so much. First of all, I want to applaud the author for bringing this reform forward. And I'm going to be supportive of the measure today, but do want to share an item that I do have some concern about and had an opportunity to be able to speak with the author about this last week. Madam President, I am grateful for the privilege to be able to represent 40% of the California coastline, from the Golden Gate Bridge to the Oregon border. And the members of the Coastal Commission are supposed to be the protectors of our cherished coastline, and trust must be restored with the membership and with the residents of California. And I'm also a firm believer that there needs to be a bit of work on this bill, specifically regarding the involvement of local elected officials. There is no bigger issue on the coast than development. And I do have some concerns that local elected officials who are elected to be the voice of the people and who are in charge of passing the local coastal plan, which is essentially the development plan for that county, specifically Board of Supervisors, may not be able to directly contact a coastal commissioner. And the reason why I have some challenges with that is that locally you have to adopt the local coastal plan. That is the development plan for that region. And then you have the Coastal Commission, who has the ability to chime in on any specific development that is moved forward at the county level. And if you're not allowing a local elected official to have direct access to that commissioner, we have a problem, particularly if the commission goes sideways from the local coastal plan. So what I would say is want to work with the author on this important issue. Again, do we need reform? Yes. Trust must be rebuilt with the residents of California. But I do think that there are some areas that I'd like to be able to work on. And the final item is this. We have entire communities that are within the coastal zone that literally have to go into the Coastal Commission to even access a coastal permit for a sign on a business. And that is why I think it's going to be really important as this important bill moves forward that we do bring in the voice of local elected officials. But I do, again, want to say thank you to the author for bringing this forward today, because I think it is some badly needed reforms.
Thank you, Senator McGuire. Senator Wachowski?
Madam President, I wasn't prepared to vote for this bill when we came in this afternoon. I've talked with the author from Santa Barbara, and I met a couple of times with the author from Santa Barbara on this measure, and I was concerned about eliminating the an ex parte communication, because as other speakers have said more eloquently than I, that they happen all the time, and sometimes people just walk up and start talking to you. I had a concern. I served on the Bay Conservation Development Commission, and I was thought that, I remember serving there, that before each meeting started, in the spirit of full disclosure, that members would indicate that they had had an ex parte communication. And as my colleague from Healdsburg indicated, a lot of these are local electeds. I met with the executive director, and he informed me that it is against the law to have an ex parte communication with BCDC, but the practice is that they have numerous ex parte communications, and they simply disclose it at the beginning of the meeting. That's probably not the best. That's a practice. It's not the best resolution. I'm concerned, as other members have said, about the situation that prompted the legislation. There's in Los Angeles, when you have an ex parte communication, you wait 4 months in order to say anything, and then you indicate it like that corrects everything. It's the spirit of the disclosures that people have. There's a big benefit for frank conversations with staff, especially if you disagree with staff and you're an elected official or you serve on the commission. With great reluctance, I will be voting for the bill today. I wish the senator from Santa Barbara good luck. I will continue to share with you my ideas of the benefits of having different types of communications on the board.
Thank you, Senator Wieckowski. Members, is there any further discussion or debate? Seeing none, Senator Jackson, would you like to close?
Thank you very much, and I very much appreciate the debate. I've taken notes. I appreciate that the bill is a work in progress. The ultimate goal, I would like to reiterate, is to restore the public's faith and confidence in this very important entity. I would like to share with my good friend from somewhere down south or east or whatever it is, Orange County, there you go, that the Coastal Act is not something that we as a legislature created. It is, in fact, an initiative that was passed overwhelmingly by the people of the state of California, which is thus part of the reason this is such a unique and different entity. The task of the Coastal Commission is to enforce the Coastal Act, and it is the task of the staff to prepare the documentation and reports, which then go to the commissioners. It is the commissioners, not the staff, who decide what is to happen. And as the decision maker, as was pointed out, they are the judges. And in our society, we insist that our judges be impartial, that they have all the facts that are available to them, and that they make their decisions, if you will, in a courtroom or in a hearing in front of the public, that they explain their reasoning, that everybody have an opportunity to express their opinions and be heard. Ex parte communications are anathema to that process. That is the focus by which I am attempting to move this bill forward, and I certainly will consider the suggestions and recommendations that each and every one of you present as this bill moves. But as my good friend from Agora Hills pointed out, this process has Agora Hills, I got it, right. It's close to me, I should know where it is. That this process has become flawed, seriously flawed, and as my colleague from Los Angeles pointed out, that former member Terry Friedman, who has submitted a letter to us, to me, and that I've disseminated to some of the members and to anyone who wishes it, when he first introduced this bill, and my good friend who has the Senate history because of his longevity in this body will probably remember this was a measure that was passed by large majorities that was designed to prohibit ex parte communications with interested parties such as lobbyists and developer applicants. But what's happened today, and I have seen this myself, that these lobbyists, these quasi-lobbyists, literally travel with the coastal commissioners. They are everywhere. I was at a reception, and all the lobbyists were there talking about specifics with the members of the commission. It's kind of like being at an event with judges and having the litigants there chatting with the judge over a beer or a glass of wine on exactly the issues that were going to be presented in court the next day. This is something that is contrary to the fundamental principles of our democracy and due process. And with that, I will pledge to continue working on this bill. We really need to restore that public confidence. The Coastal Commission, again, as I mentioned, was created by and for the people and is one that must have the support of the people in order to function effectively. And with that, I would ask for your aye vote.
Thank you, Senator Jackson. Mr. Secretary, please call the roll.
Allen? Aye. Anderson? No. Bates? No. Bell? Aye. Berryhill? No. Block? Aye. Cannella? No. DeLeon? Fuller? Gaines? No. Galgiani? Glazer? Hall? Hancock? Aye. Hernandez? Hertzberg? Aye. Hill? Aye. Weso? Huff? No. Jackson? Aye. Lada? Aye. Leno? Aye. Leva? Aye. Liu? McGuire? Aye. Mendoza? Aye. Mitchell? Monning? Aye. Morlock? No. Morrell? No. Wynn? Nielsen? No. Pan? Aye. Pavley? Aye. Roth? Aye. Runner? Stone? No. Vidak? No. Wykowski? Aye. Wolk? Aye.
Please call the absent members.
DeLeon? Fuller? Fuller, no. Galgiani? Glazer? Hall? Hernandez? Weso? Liu? Aye. Mitchell? Aye. Wynn? Runner? DeLeon, aye.
Glazer, aye. Oh.
Glazer, aye. Hall, aye.
Ayes 23, noes 12. The measure passes. Thank you, members. Moving on to file item 22, Senator Leno. Mr. Secretary, please read.
Senate Bill 1288 by Senator Leno, an act relating to elections.
Thank you, Madam President. Colleagues, this bill, which has no opposition, is all about local control. Under current law, general law cities, unlike charter cities and districts, do not have authority to choose between a plurality voting method or a majority voting method. Some charter cities do have the plurality. That would be Los Angeles, San Diego, San Jose. Some charter cities like San Francisco, Berkeley, Oakland use a majority voting method. This would just give authority to general law cities to be able to choose by a vote of the people, just as charter cities already have. It requires no city or district or county to change any voting method. It just gives authority, allows the voters, rather than Sacramento, determine how they choose their voting method. It has no opposition. I ask for your aye vote.
Debate or discussion? Seeing and hearing none, Mr. Secretary, please call the roll.
Allen? Aye. Anderson? No. Bates? No. Bell? Aye. Berryhill? No. Block? Aye. Cannella? Aye. DeLeon? Fuller? Gaines? No. Galgiani? Glazer? Hall? Aye. Hancock? Aye. Hernandez? Hertzberg? Aye. Hill? Aye. Weso? Aye. Huff? No. Jackson? Aye. Lada? Aye. Leno? Aye. Leva? Aye. Liu? No. Liu, no voting. McGuire? Aye. Mendoza? Mitchell? Aye. Monning? Aye. Morlock? No. Morrell? No. Wynn? No. Nielsen? No. Pan? Aye. Pavley? Aye. Roth? Aye. Runner? Stone? No. Vidak? Wachowski? Aye. Wolk? Aye.
Please call the absent members.
De Leon? Fuller? Fuller, no. Galgiani? Glazer? Aye. Hernandez? Aye. Liu? Mendoza? Runner? Vidak?
Ayes 23, noes. Ayes 23, noes 12. The measure passes. Moving on to file item 23, Senator Berryhill. Mr. Secretary, please read.